Hi, I'm Natalia Angelini.
And I'm Doreen. So,
Welcome to Cullen Estates. You're listening and watching episode number 592. Today we're going to be discussing a recent case by the name of Re Timmerman Estate. We'll have the link up on our website. And it's an interesting case that deals with the disposition of a body.
yeah, it's an interesting case, and it's quite an unfortunate case. You don't generally see too many reported decisions on issues relating how the body is to be dealt with once someone dies. Usually, next of kin or estate trustees will be able to make that decision about, cremation, burials, and be able to carry out that decision without too much trouble. But this is a case that went to the court. It was heard in writing, and it was actually heard 7 months after the deaths of Marguerite and her son, Craig. And this really kind of all originated from the fact that neither of them had wills when they died. And that's really where the problem began, is because there was nobody with a piece of paper that said that they had the authority to make these decisions.
Right, and the law is clear that the executor is the sole person who's got that authority, and their obligation is to dispose of the body in a way that is dignified. And there is a case that's called Saleh and Reichert. We blogged on it several years ago, but it was an interesting decision where the deceased was of Muslim faith. And when the deceased passed, the deceased father had objected to cremation on religious grounds and was ultimately unsuccessful. And the court affirmed that, the fundamental duty of an executor is to ensure that the remains are disposed of in a decent and dignified fashion, but religious law has no bearing on the matter. So that's sort of the general basic point, is the executor's got the authority. And in this case, there was no executor. And maybe let's get a little bit more into the facts so we can give some context.
Yeah, absolutely. So Marguerite was the one who died first. She was the mom. She wasn't married, I suppose, at the time, and the decision doesn't speak to a husband or a spouse or anything. So Marguerite dies on October 16th, 2019. She had two children at the time. They were both adults, Craig and Shannon. Craig unfortunately died 1 month after Marguerite. He died in November 2019, and then all that was left of Marguerite's family was Shannon, her daughter, as well as a sister named Marilyn. Because Craig did survive his mother by a month, Craig did start to make some of these arrangements, and he was able to communicate with his aunt Marilyn that his mom wanted to be cremated. And Marguerite had conveyed those wishes to Marilyn as well. And
Right. Her and Craig both had the same recollection in terms of mom's wishes that she'd expressed before she'd passed.
That's right.
Yeah.
Now, because Marguerite didn't have a will and this is an intestacy, her estate, and Craig having died afterwards, her estate basically gets divided 50-50 between Craig and Shannon. With Craig gone, the priorities under the Estates Act in terms of who has priority to act as a state trustee goes to Shannon first as the next of kin, because Marguerite did not have a spouse. But unfortunately, Shannon did suffer from a lot of, I believe, mental health issues at the time. There were a lot of social workers that she came into contact with who ended up concluding that she was incapable of even, giving instructions as to how to deal with the body, or even consenting to Marilyn dealing with the bodies.
Right, because Marilyn had wanted to be appointed executor, right?
Right.
And Shannon, what I gather from the case is that Shannon did not want a cremation to take place. She did want a burial, but she wasn't able to actually follow through and pursue that. She sort of disappeared, and she was in communication with, like you say, the different social workers. She was incoherent, right? There was a real challenge in actually trying to understand her, and a real question as to her capacity.
Right. So practically speaking, if you look to the Estates Act, who has priority to act as an estate trustee on an intestacy, you don't, in this particular situation, the court didn't have someone who was going to be able to act and deal with things in a practical and efficient manner. And that's how it got to court 7 months later, because 7 months later, both Marguerite and Craig were still at the morgue at the Kingston Hospital. And Craig himself was not married at the time. He did not have a spouse at the time. He didn't have any other next of kin besides Shannon, although he did have a minor son at the time whose location was also unknown because he did not have a relationship with his son. So really, at the end of the day, everything fell onto Aunt Marilyn's shoulders. But she was the one that was happy to take it on. She applied to the court for an application of certificate of appointment of an estate trustee without a will in both instances. But because of the legal requirements to file that application, requirements that, involve service on Shannon's renunciation because she has that priority under the Estates Act, as well as her consent that Marilyn can act, all of which just led to, obstacle after obstacle for Marilyn.
Right. Because none of those requirements have been met. But the court, I think quite rightly, and actually one thing we didn't mention is, I don't know so much about Craig's estate, but Mom's estate was extremely modest. We're just talking about maybe like less than a couple of grand. So that has to be kept in mind, that there were no funds here. And so
absolutely. And there were no funds in Craig's estate either. So the court actually issued 2 decisions. They heard both applications for probate at the same time. And we'll post both links up on our website.
Right. And the court really reasoned that, it accepted the applicant's evidence that the mom did want her remains, she did want to be cremated, and found the delay to just be unconscionable due to to the difficulties that the applicant, Ontario Works, and the hospital had in seeking and getting instructions from Shannon. And the court felt that the applicant's efforts had been reasonable and appropriate, and also that Shannon had ample time to express her wishes, and she was never ultimately able to do that. So the court granted the application, even though those formalities weren't complied with.
Right. And really, at the end of the day, for this one, it was in the interest of justice to waive the requirements of service. Even under the Estates Act, Section 29 is a section that gives you the priorities as to who is entitled to be an estate trustee on an intestacy, or even where you have an instance where an estate trustee is named, but he or she is either unwilling or unable to act. And that first priority is, again, the spouse, then it goes to the next of kin, and then any combination of those 2 groups of people. Right. But there's still a reserved jurisdiction for the court to, under subsection 3 of Section 29, to actually appoint a person that the court thinks most fit for the job, so to speak. Right. And at that point, it can even be a trust company.
Right. Which would have never happened in this case.
No. So unfortunate that they both died impecunious, but it is wonderful that Ontario Works, I think, is able to pay for the cremation for both Margaret and Craig. It was just, the ability to have somebody sign off on all the paperwork that held things up.
Right. So Doreen, I think unless you've got any other thoughts, I think that ends our podcast for the day.
I think so too.
We do want to thank everyone for listening and for watching. I'm Natalia Angelini.
And I'm Doreen.
Should you have any questions, please email us at webmaster@hollandhull.com or leave a comment on our blog.
Thanks.
Thank you.